Good afternoon, everyone, and welcome to our fireside chat, High Stakes, No Excuses. I'm Chris Ryan, the Chief Strategy and Marketing Officer at Aviante, and I'm pleased to host this important conversation. Before we get started, there are a couple things I want to touch on. First, I want to remind everyone that Aviante is not a law firm, nor can we dispense legal advice, and we encourage all of you to retain qualified legal counsel before making any important changes to your current regulatory or compliance practices. Secondly, and let's acknowledge the elephant in the room, immigration is a complex and polarizing topic, and we aren't going to solve it today. Rather, we are going to focus around providing staffing agencies and employers with the practical tools and strategies to help you build and maintain a strong compliance posture for your business. And to do this, we're going to explore several key questions. Things like, how are ICE enforcement tactics evolving? What makes staffing agencies particularly vulnerable to an I-9 audit? What exactly happens during an ICE raid or audit? And if it's your agency, how should you respond? We'll also explore how digital tools can help automate compliance and mitigate legal risk. And most importantly, we'll talk about what practical steps you can take immediately to protect your business. So let's get started. In January of 2025, the new administration issued sweeping executive orders on immigration enforcement, signaling a dramatic shift in how federal agencies approach workplace compliance. An early indicator suggests that we're entering what may be the most aggressive immigration enforcement environment in nearly a decade, with ICE raids and I-9 audits surging across multiple industries. What's particularly concerning for staffing agencies is that Form I-9 isn't exactly new. The legislation behind it was passed back in 1986, and frankly, it should be old news. But what has changed is the enforcement landscape. Digital enforcement techniques, including data sharing between separate federal agencies like the IRS, Social Security, and the Department of Homeland Security, means that Immigration and Customs Enforcement, or ICE as it's affectionately known by the media, can now pinpoint compliance violations with precision and efficiency. And we're seeing the results in several recent headlines. In March, a manufacturing plant in Texas lost 20 workers in a single day after an I-9 audit. In April, a roofing company in Washington State had 37 employees, nearly a third of its workforce, detained in a dawn raid. And one of my favorites, a concrete manufacturer in Mississippi, claimed they weren't responsible for the unauthorized workers at their worksite because the workers came through a staffing agency. But as it turned out, ICE considered both parties at fault. And these cases all highlight a troubling reality. Staffing agencies are increasingly finding themselves on the front lines of immigration enforcement, and staffing is inherently more vulnerable than other types of businesses due to high volume hiring, rapid onboarding, and shared employment responsibilities. And beyond the workplace disruption and reputational damage, ICE enforcement can result in crushing penalties. One example, in 2022, a staffing company with over 2,000 Form I-9 violations was ordered to pay more than $1.5 million in penalties. So even simple paperwork errors can be quite costly. There is some good news. With proper systems and processes and compliance safeguard, it is possible to navigate the environment and mitigate your business risk. And to help us unpack this complex topic, I'm joined by two distinguished experts. Leah Elliott is a partner with Staffing GC, a law firm exclusively serving staffing firms. Leah brings over 20 years of legal and executive experience in workforce solutions and staffing. Her unique blend of legal expertise and hands-on industry experience makes her the perfect guide for today's discussion. So welcome, Leah. Also with us today is Sushma Tripathi, Aviante's Chief Product Officer. Sushma oversees the design and user experience for all Aviante software products, including our automated onboarding tools. She brings more than 25 years of experience in HR, staffing, and human capital, with hands-on experience designing HR and staffing systems. And our hope is that by the end of our discussion, all of you will be able to pick up at least a few actionable strategies to enhance your compliance posture and protect your agency from financial penalties and reputational damage. So let's get into it. Let's begin with Leah. Leah, you've been in the trenches of staffing compliance for over 2 decades, what's keeping staffing executives up at night in 2025 that wasn't on their radar 5 years ago?
Well, certainly the immigration enforcement posturing is absolutely one of those, right? Very much the topic we're going to be talking about today, and happy to be here to discuss all that with all the attendees and Aviante. So that one goes without saying. It had a rapid ascension to kind of the top of the list. And then outside of that, we really see economic uncertainty spurring concerns that maybe weren't there before. I see a lot of executives starting to prioritize, what don't I know? Like what does this economic certainty, what are the blind spots and exposures that I might have? And if the floor starts to fall or some sort of uncertainty takes hold, where is most of my risk sitting at? And who owns it within my company, honestly, because it's not just a matter of just thinking about all these issues, but having the proper workflows and operationalization of your workflows to make sure someone owns it, right, and is accountable for it. That helps people sleep at night a great deal. Third would just be kind of the state by state compliance patchwork. That's always a problem. But really, the bulk of the calls that our firm is receiving just in the last 30 to 60 days in terms of reactive and kind of like questions coming at us to react to have largely been around immigration enforcement. There's just been a great deal of activity in that space. ICE agents coming to staffing firms. Some of you may have seen over the weekend, there was an enhanced partnership with local law enforcement in Miami. 800 people were detained, right? This is the kind of stuff that's just churning in the headlines and is causing some pause and planning in the C-suites across America.
Yeah, yeah. So I guess one of the critical questions here is way beyond financial penalties and compliance. It's business continuity. It's, are you suddenly going to leave an employer in the lurch because people you thought were qualified to be staffed are no longer qualified? And actually, to that point, I noticed only last week we had a couple of customers that we're aware of where e-verify employment authorization was suddenly being revoked for people who previously had e-verify. So I thought that was clearly, things are changing in a way that we have never seen before. So it's not the law isn't changing, but the enforcement sure seems to be. Yeah.
It is. It is. And to your point about revocation of employment authorized status, just up until a week ago, until, like April 20th, a lot of my clients were concerned with regards to the change and the acceleration of the expiration date on the C-11 work authorization status, and had clients with hundreds of people at issue that they were suddenly preparing for, letting employees know they needed to bring in updated work authorization documentation if they had it. And then the court system catches up and hits pause, right? Issues an injunction. And so there's this constant, we're ramping up and then we pause, and then we ramp up with something else and we pause. And so it does feel roller coastery for sure.
Yeah. So let's talk a little bit more about I-9 and immigration law. I think the original law, the immigration, enforcement, act was passed back in 1986, and yet suddenly it's causing panic now. So, what exactly has changed from your perspective in the enforcement landscape that makes this law so dangerous now? It's the law itself is pretty clear. I mean, it's simply a question of how we're going to enforce it, correct?
It is. It's a dinosaur law by most measures, right? I mean, this has been around since the mid 80s, and the substance of the federal statute itself has not changed. What has changed are the executive orders to the federal agencies, which, if you think about, the president being like the CEO of a company and the federal agencies being those divisions and departments that the president leads, instructing those folks, here's what I want you to prioritize and enforce, and equipping them with the resources and support. And then that coupled with it garnering really big headlines, right? We're getting a lot of media, no matter what side of the aisle you're sitting on. It's like a fire hydrant of information on a daily basis. And so really that the actual change in enforcement and then the perception and the change in enforcement are together creating this, monstrosity of anxiety for employers and staffing firms, feeling like, man, we really want to look at this and make sure we have kind of our ducks in a row, um, because of the fact that the way enforcement is being approached, the aggressive nature that's being taken. We're even seeing, for example, in ways that we've not seen enforcement happening before, and I've been doing this for 25 years, not to date myself, but man, it's been a long time, and I've not seen this particular approach, which is that I'm hearing from several staffing firms, and they straddle industries and geographies. So this isn't, something kind of focused in a specific geography or a specific industry being served by that staffing firm, but ICE agents just showing up in the branches and saying, hey, we're here to introduce ourselves. And they talk to your front desk person. Are you employing anyone who's not authorized to work? Right? Just coming in and asking questions, not serving a warrant, not providing a notice of an audit, truly just drop-in visits, and not necessarily targeting staffing, because we're hearing that they're going like up and down strip malls and throughout entire commercial buildings. And so this new approach to making sure that that they're there is a new technique that we've not seen before, that they're using to make sure that you kind of keep it top of mind.
Yeah, so let me ask you that. Is there a pattern to how ICE is visiting companies, and and let's talk a little bit about this concept of digitized enforcement. So if you suddenly take Department of Homeland Security data, like the data that would be used by E-Verify or a Real ID program, and you're suddenly cross-matching it with Social Security and IRS data, which has never been done, essentially has never been done before. What does that do? I mean,
Yeah. I mean, that's just enabling them and the federal agencies and the government to move more towards data-driven decision making, right? Which is what I think all of us are doing in our own organizations. We're trying to take data that's made available to us and use it to make better, more strategic decisions that move our business forward. And for ICE, their quote unquote business moving forward, right, is the detention and the elimination of individuals who might not be authorized to be in the country. And so they're gathering this from, eons of sources, right? It's agencies sharing data, not only Social Security Administration, IRS, and Department of Homeland Security, but you see state departments like DMVs feeding up into federal databases now. You see data collection via surveillance. There's an awful lot of facial recognition and AI incorporated into this. And something a little bit new and novel is around not only the information sharing, but the GPS monitoring of folks, right? So as detention centers fill, ICE has begun utilizing, presumably with nonviolent detainees, um, the equivalent of like ankle monitors, right? And some sort of device that will geo-track where folks are at so that they don't lose sight of people. So it's just a lot of new coming at us in a lot of different ways, and in from a huge diverse source, of ways that they're tracking. They're really seeming to try to capitalize and take advantage on as many resources as they can get their hands on.
So, I mean, from your standpoint, is getting a new job going forward going to be any different than entering the country through customs? I mean, ultimately, is that what it's going to look like? We're going to.
Yeah, that's what it feels like, doesn't it? All right. I mean, I know for employers have been put on the front line of this immigration enforcement. That's not the right term, but employers are on that front line because we're charged with confirming work authorization and identification, right? So it does start to feel like it's that far in the weeds, you know. It's definitely an administrative burden, and employers, like in so many other areas, are being put on the front line to, you know, quasi administer it.
So let's talk about the concept of good faith compliance, because historically the law was designed so that, you know, employers were expected to keep certain records and to collect certain records at the time of employment. But ultimately, the employer was considered to have safe harbor, provided that they followed certain rules regarding, you know, if somebody wanted to submit false credentials, it wasn't necessarily the employer's expertise to be able to identify false credentials unless they were obviously, you know, or clearly fake. But, you know, to talk about that a little bit, you know, is the good faith shield changing, and has that protection evaporated going forward?
It's not gone. That hasn't changed. That employers still, you know, if you accept a document that appears reasonably legitimate on its face, the documents in support of the I-9s, whether it's a list A or a list B and C document, right? If they appear reasonably legitimate, not only the employer should accept them, you must accept them, because you can't go too far the other direction and over scrutinize. So what you don't want to do is to, you know, deputize your workforce and turn them into these super sleuths, digging up every single ID and, you know, investigating, spending half an hour making sure that thing is legit. That's not the standard that's required. One, it slows your business way down. But two, it gets you on the flip side of not only of the I-9 and immigration law, which is the discriminatory side. And so the, you know, the middle ground, the fairway is pretty narrow for I-9 compliance, and it's hard to keep that golf ball down the center. If you go too far in either direction, whether it's over scrutinizing or under scrutinizing, you've violated a law technically. So it's, you know, it's absolutely important. It underscores the importance of training, in my opinion, to make sure that folks know, equip them with what it means to look at the documents that are presented to you, to make that initial determination in good faith that it's not a pink social security card, it's not a passport with a picture with somebody with, you know, a bird on their shoulder or something ridiculous, right? I mean, those are the kinds of things that, if you have that, that's going to be deemed knowingly, you know, a falsified document. If you don't have a reason to believe it, obviously you still have that protection. You might get some, in today's environment, you might get some, you know, exposure on, you know, allegations of not hiring, and it takes some time to work through getting you to that defense, but it's a defensible posture that's still available.
Yeah. Now, what are some of the challenges that are unique to staffing firms? You know, obviously, the hiring volumes are significantly higher, and you're going to have decentralized branches and operations. So talk a little bit about that. I mean, in an employer, you have a centrally trained HR department. It's a little different in a staffing agency.
Absolutely. Yeah, with the network of branches that many staffing firms operate under, right? With this network of branches all across the country, you have so many different people to train and make sure they're continued to be trained, and that they understand your your workflow, that they understand your SOP when it comes to I-9 documentation and processing and review. That by itself is a massive distinction that staffing faces, right? It's not centralized. Your point uses the perfect term, is that it's very decentralized. And then just the multiplicity of the number of work sites that staffing firms serve. So whether we want to or not, we kind of get pulled in historically, client by client. So if there was an audit, if there was a raid, something happening on a client site, you know, staffing firms have usually been brought in as kind of the secondary layer to a client's audit or raid or investigation going on, and then they go out to all the suppliers. And that can be, cumbersome. Certain work sites can be higher risk for staffing. For back, you know, 5 years ago, maybe 7 years ago, the poultry industry was notorious for audits and raids and things happening in poultry processing facilities. So some of those types of industries you might see, spike up a little bit here and there.
So let's specifically talk about good faith from a standpoint of, staffing agencies have to, maintain their I-9s, and I'm going to have Sushma jump in on this as well. When we talk about what, how do you ensure that if ICE were to come in and audit your HR records, and you're a large staffing agency, you got a lot of branches out there, what specific documentable practices translate to good faith in the eyes of an ICE auditor? And obviously, every ICE auditor is a little different, but what have you seen? And then I want to have Sushma jump in on this as well.
Sure. I mean, ideally, if I have a client who's going through an ICE audit and we're in a position that we need to produce documentation, which is the I-9s, what I ideally like to be able to do, and what helps to make it as easy as possible for them to find in our, maybe not in our favor, but not against us, is to have a solid standard operating procedure and policy under to your internal teams, right? This is your internal team's instruction manual and guidance with regards to how I-9s are processed, what the standard of review is, documenting the training, right? The ongoing training, and how they escalate questions and concerns, right? Just having something in place foundationally that you can help show, look, this isn't just a one-off person and they did everything right, but we're systemically dedicated. Our culture is one of compliance.
So having a single standard procedure, having it written down, having it trained, having presumably consistent record keeping processes. So, how would you answer that, Sushma? And, obviously, as somebody who designs products and are thinking about, what do we need to do? And this is an existential question for Aviante. What do we need to do to ensure that our customers stay compliant and are able to operate their businesses effectively, well, without bureaucracy, but to have the right records when an audit occurs?
Right. So, that's a great question. And I have to say, I fully agree with everything Leah just said. Like literally, you've got to have procedures in place. But then, when you think about from a product and operational perspective, good faith compliance means that having systems that actively promote the overall purpose of the regulatory requirements, right? And it's not about checking the boxes. So, a lot of time people think about checking the boxes. So, when we think about good faith compliance as we are building products, it's about what tangible product actions can be taken. How do you document them? So, building compliance into design, thinking about design from day one. That's how we think in product, right? So we think about compliance as we design product. This means, we're taking a systematic approach to how we build and integrate with other products, having a problem-solving mindset, right? That's another thing. Also, we're continuously looking to provide tooling to agencies to conduct regular compliance reviews. What Leah mentioned, right? You have SOPs. And so your people must follow SOPs. How do you make sure people are following SOPs? So what's the reporting and dashboards that are available to see some of that? And the most important thing is, agencies need to make sure that their people are following their standard operating procedures. That is the most important thing. So how do you know that? And then, it also means having robust documentation for, compliance reasons. And then most importantly, having a fast track process if to make any fixes that are necessary, right? So that's what we are continuously thinking of. So if I have to sum it up, I'd say, the gold standard for good faith compliance in product development is about creating a culture where doing the right thing is a part of our DNA. So that's how I would describe, how myself, my team thinks about it, not just something to, just avoid fines and penalties. So we're thinking of it systematically.
So in fact, as we think about that user design of technology, making sure that it's convenient, if you suddenly need to produce 500 digital records, if you need to produce an exceptions report to identify 30 people who haven't completed their I-9 yet, all those small details within the product are absolutely critical on an ongoing basis.
Yeah, so Chris, that is absolutely right. So, let me give you a couple more examples of that, right? First of all, you got to flag, which documents are coming up to expiration dates, right? Which ones are going to expire? So you got to keep a track of that, request re-verification. You have to include audit trails of all verification activities that you've done so that you can, demonstrate what was done by whom, when, and why. And I think Leah talked about that a little bit, but like having a systematic approach to have all of that documented so it can be retrieved when you need to show it. Also supporting compliant correction practices, right? So mistakes happen. So if mistakes happen, how do you correct it? How do you notify people? All of that. And then finally, from a product management standpoint, as I mentioned before, right, that reporting and dashboards to show compliance metrics. So if I had to think of a key takeaway, good faith isn't just about intent. It's about having the documentation system and processes and practices that demonstrate the agency's commitment to compliance. So they have to demonstrate what they did, not that, oh yeah, I meant to be compliant and all of that. At the end of the day, you have to prove it. And
so you can't just say sorry. It
Yes.
has to be competent execution.
And I see Leah smiling because I'm sure she's aware of that from, various client interactions she's had.
Yeah,
So
nobody intends not to comply, right? I mean,
yeah.
it's you stumble upon I-9s with errors, and that's not intentional. Yeah.
Yeah, I mean, you have to send it back. It's a lot of back and forth. You've got to document all of that. There are time frames. There's the 3-day, the 10-day, all those different rules apply.
Yeah.
So it's pretty complex.
So Leah, paint us a picture now. Now let's talk about a worst case scenario, and you alluded to it a little earlier. ICE can show up, and it's 9 a.m. on Tuesday. It's just another day in paradise. Operating your staffing agency business, and ICE agents pull into your parking lot, or maybe they pull into your client's parking lot, and take us through the next 12 hours. What unfolds during an ICE raid? And maybe we should just say they're different. There's an ICE visit, there's an ICE raid, there's an ICE audit. But let's talk, let's unpack that a little bit. What actually unfolds and who's at risk, and what immediate actions should a staffing firm take?
Yeah, I think it's a great question, and it's one that we're doing a lot of training on right now because the increased visibility of ICE, physically presenting to work sites and making sure those frontline folks understand the various reasons for the visits, and then what to say in response, as well as who to escalate and bring into the fold. And so I would say if your client is either served with an audit, or you hear about a raid that's potentially happened at a work site, I would try to stay calm. If I'm the staffing firm, I'm going to try to just pull back a little bit. I'm not going to call the client or go out there or try to. You don't want to create more havoc around what is probably already an anxious situation. We all know the client's going to call you, right? I mean, have no doubt. They're not going to let you just, slide, but let them reach out to you. I think one of the biggest things staffing firms can do is to build bench depth in terms of their contacts within your customers. because it's in those type of situations that you want to make sure that you have your highest level HR, COO, legal, whoever it is, connecting with their counterpart at your client facility, because there will be rampant rumors at middle management level and down, right? So it will just, you don't want to take information, you're going to hear that information. What you don't want to do is react based upon it until you know you have credible information coming from your clients. So I do encourage people to make sure you have those contacts within your clients and that you maintain those relationships. Very, very important in a time of perceived crisis like that. It's very different for ICE if the agents come in and they serve a warrant, and there's two types of warrants. There's a judicial warrant and there's an administrative warrant. And if you don't know the difference between the two, you want to be trained upon them. Your responses are very different. A judicial warrant will be signed by a judge and is ordering and allowing, it's going to describe where those agents can go within the facility, which may include non-public areas. It could be for a mass raid. It could be to go look for and identify and potentially detain a certain individual who they believe to be on the work site, right? It could be, it's like, true kind of criminal warrants type situation. An administrative warrant does not do that. It's a very different warrant. So it looks the same, and it comes on a Department of Homeland Security form. So it looks very official, and it is official. But what it has the ability to do, what you're mandated to do legally, is very different than if a warrant is signed by a judge. So you want to understand so you don't accidentally volunteer and let someone into a private area, non-public space when maybe you didn't have to, and if given the choice, you wouldn't have, right? So very, very important.
So let me ask you about that for a moment. Typically the person who's going to be greeting ICE at the front door is a 25-year-old receptionist, and
Yep.
I don't know whether they're going to show up in tactical gear or not, or how, what they might look like. But I think your first instinct would be, gee, would you like to wait in the conference room down the hall, next to, the stacks of filing cabinets or something like that? Talk to us a little bit about how you prepare for that and how you prepare the receptionist.
Yeah, you definitely, that front desk person, whoever that first person is that someone would encounter. It could be a security guard. It could be, if you've got security on the property, most staffing firms don't, your clients might. If they come in and they come up to that front desk, you want to equip that poor person to deal with it, right? Because the last thing you want is for them to feel intimidated and scared, not know what to do. And being in staffing, we are inherent people helpers, right? We help people find jobs and make connect to an ability to, support themselves on a daily basis. It's not going to be any different when law enforcement comes in, and the psychological impact is often, well, if I just answer all their questions, they'll leave and we'll get this done quicker, and so, but they might be asking questions that you don't necessarily need to answer right then, or maybe asking for documents that you don't need to produce at that very instant, right? So it's really important to make that frontline person aware of the possibility so they're not caught off guard. You're not trying to turn them into legal experts, but if there's someone internally you would have them escalate that to, give that person a stack of those business cards and say, when they come in and they serve a warrant, or they're requesting some documents, they can say, I'm not authorized to do that. Here's the person you can contact. Give them that information. If they're coming in with a judicial warrant, maybe it's a little different. You need to have a plan for who do they contact if they do have permission to come into a non-public space. 9 times out of 10 at a staffing firm, they're not coming in with a judicial warrant. They're coming in serving a notice of an audit in which you have specific timeframes within which to respond. Most times it's extended, and we secure, voluntary agreement to extend those periods of time. So you just need to let that person know that, look, this isn't we're not putting this all on your shoulders, right? Here's who you give the card to. You can accept whatever documents they provide you and let them know you'll share those with so-and-so. And that person will get back to them, make sure they collect the agent's cards, right? Identification on there and a good contact phone number or email address, and leave it at that.
Yeah. Now, doesn't ICE have to provide 3 days notice at least for an audit, a typical audit? And so the expectation is that you would get 3 days notice, and then you have to produce all your forms and documents. Is that
correct? That is correct. They won't necessarily voluntarily tell you that, though, right? They might say, let's just get this over with and pull all your I-9s. And some companies might feel pressured to do so, right? So that's why I say it's important to train and to talk about it so that it doesn't feel so overwhelming when and if it happens.
Yeah. So,
because like you said, they do come in, and I mean, one of my last clients called, they did come in full kind of gear, I mean, they had, they've got, I mean, they look like ICE agents, right? They've got tasers and, weapons and badges, and came in some sort of all-terrain vehicle, honestly. I mean, it wasn't a tank, but my poor client's, front desk person was like this, strange kind of sand-colored vehicle that looks like it could go ATVing in the desert, pulls up, and just like, what the heck is this? And then that person comes and talks to you. Like, that feels kind of scary, right? We just, and knowledge is power. So we want to make sure people are equipped with as much knowledge as possible.
So if you were actually running your own staffing agency, and you knew for certain that you were going to be audited or rated within the next 60 days, what steps would you be doing right now? And actually, I think this is an important point for our audience. My assumption is, if you're operating a staffing agency, at some point you are going to be audited or have a raid. You just assume that. But how do you prepare? What would you do?
Yeah, I think it's a good question, and it's one that lays the framework for how do we set the culture of compliance and make that assumption ongoing, right? Just assume, and sometimes it's not even government pressure. What if your clients start, because they're asking for attestations now? Obviously, we can't share the Form I-9s with the clients directly, but they're going to ask your CEOs to sign a document under oath that you have valid I-9s for every single person that you have assigned to their facility, right? So business is driving a lot of this as well, in addition to kind of regulatory compliance. And I would start with where we should be reviewing on an ongoing basis, which is who is currently working with an expired work authorization status, if anyone. Hopefully it's a big fat zero, right? If you're electronic, you're running reports, take a look at that thing, have it auto generate and deliver those reports to whoever owns that piece of compliance for your organization, to try to minimize those that slip through those cracks. So I start with who's currently working and on a expired status, if any. And then secondarily, start looking at the scope of what would it look like to audit all of our currently working employees. And if you know you're being audited in a particular place, you've received that notice, you're going to get looked at, start with that location, start with that branch. If it's specific to a client, start with employees currently assigned there, right? Start limited and then get bigger as you go. The final piece that I would look at is anyone paying attention to the document retention policy you have in place for your Form I-9s? And whether that's paper or electronic, document retention sometimes gets kicked to the curb because we have a whole lot of other things to think about besides how long are we supposed to hold on to this document. It's really important in the I-9 space because if you over retain, it is subject to being produced in the event of an audit, which means any mistakes or errors can then be tallied up for purposes of penalties and enforcement. So we do recommend some sort of regular cadence of review for what I-9s are eligible for destruction and when. You don't want to terminate them too early, obviously, but this also isn't a situation, if you hold on to payroll records forever, you might, it probably costs a lot of money. There's infrastructure issues there, but it's probably not as much of a concern because you're not necessarily going to need to be in a position to produce. I-9s are different. They will request any and all, and that will include those. Just because they were eligible for destruction doesn't mean you don't get to refuse to produce them. So it's important to only hold on to what you have to.
Yeah, that's a very important point. So let's talk a little bit about I-9s now. And Sushma, I know as part of your process for designing an automated onboarding solution, you and the Aviante team looked at a huge number of I-9s. And I'm curious, what are some of the most common errors that one typically sees in a Form I-9? If you have especially a pile of paper, what are the typical problems?
Yeah, that's a great question, Chris. And, we've seen a variety of, ways people are tracking, especially if it's a paper form or even an electronic form that, people have to track and sort of shuffle between the employee and the, recruiter or the administrator. So, let me start out by saying that when it comes to I-9 compliance, we're really dealing with a shared responsibility. So it's the staffing agency, the employee, and then the tool that they are using. They all must work in harmony, right? So those all must be coordinated and support each other. So agencies, they need, like we talked about before, standard operating procedures that are robust and that everyone involved in onboarding must faithfully follow them. That is really number one. And then, based on our experience, we've seen several recurring compliance pitfalls, may I call them that? And, that causes a significant risk. As you think about it, first of all, incomplete or missing Section 2 documentation, right? That's a huge issue. And many agencies, they fail to properly verify the document. This includes employee identification, particularly with remote workers. It creates an immediate exposure to penalties. And then if I have to think about others, that could be something like a missed deadline that continues to plague the industry. So you have this 3-day window for completing Section 2. That can frequently exceed the time frame allotted, especially during, high volume hiring periods. And what makes this particularly dangerous, I would say, is that each late form, it represents a separate violation. And, they can all multiply and add up, literally, if you have a lot of non-compliance going on. And then third, also important is inconsistent re-verification practices, right? That also creates a vulnerability. And many agencies, they struggle to track and properly re-verify employees with temporary work authorization before they expire. So these are some good examples, but there could be a plethora of examples. These are just a few.
Yeah, yeah,
Isn't
no,
it interesting? Yeah.
yeah. Go
I
ahead,
was just
Leah.
going to say real quickly that it's so illustrative, your comments about how complicated this little form is, right? It's very deceptively misleading because it's, a couple pages. It looks like something you just fill out, a couple of boxes. It couldn't look more simple, but yet if you look at the employer handbook, that USCIS puts out as guidance, that thing's like 150 pages long, explaining to you how to fill out this 2-page I-9 form. So, I mean, it's really, I've always called it the world's most complicated form because it's just, there's so much nuance in there.
Yeah,
I
and it
totally agree. I think this
Yeah.
form is very complicated. And then, the whole thing is, and it's regulatory requirement, right? So it's not like you can avoid it. That's the bigger challenge with it. And, so the errors that I discussed, those create disproportionate risk if you think about it for agencies because of their unique circumstances. So as you think about it, there's this whole sheer volume of employees that are processed annually, especially in the staffing agency. With employers, people are permanently employed and they're working for a period of time. Turnover is low and what have you. In the staffing agency, turnover is high. You have to keep adding people. And as you add people, this is a must, and you have to go through the process. And then, the whole rapid onboarding, timeline specific to staffing industry, right? So, people want people who've been already verified to be placed there. And like you said, that could be a contractual agreement with the CEO or whoever's the head of sales in the agency. And then there's this heightened security that you already mentioned, Leah. I think, that's there. So I think all of this is pretty important to consider. So as we design products, we have to address all of these challenges and make sure, we are digitizing and automating and creating these auditable processes and so on and so forth, in order to be compliant and make sure that our clients are compliant and they have proper tooling for that.
So Sushma, that brings up an interesting point. A staffing agency could have, perfect Form I-9 compliance, and suddenly they have to onboard 200 new people at a particular work site, and all of a sudden they get overwhelmed. So, when it comes to modern staffing technology, how do we balance compliance rigor with operational speed? Because whether you're hiring one person or 200 in a given day, it's going to hit one branch somewhere in the United States is going to be doing most of this activity, and you've got to have the ability to actually handle that kind of volume. So, talk to us a little bit about that.
So, Chris, that's a great point. This is precisely the challenge we've engineered our solution to address. As you think about it, modern staffing technology that eliminates the false choice between compliance and speed, right? You got to do both. It's not a choice. It's not one or the other, right? So, the right tools enhance both and actually do both for you. So the approach we've taken is to mitigate this challenge. First of all, we seamlessly integrate compliance workflows into existing onboarding process. And, rather than adding separate compliance steps, we've embedded them directly into the natural recruiting workflow. So our digitized process at Aviante, we make sure that the automated workflows are triggered by the agency designed onboarding events. And that is really important to us. And, it eliminates a lot of these bottlenecks. So the one point I want to make there is that agencies fully control the workflow. They are in charge. They configure the workflow. They say when the workflow is triggered, what tasks, what documents and forms, all of those are included. And also in what sequence. You can have stages in which people can complete workflows. You can have a fixed stage that you have to do stage 1 to 2 to 3, or you can provide flexibility. Depends on the agency, what they want to do. They can also configure automated notifications and reminders to let people know that, hey, your form is due. In order to be placed, you're going to start your work on Monday. And so in order to be placed, you've got to complete these things. So, those are all automated procedures that we have through our 24/7 onboarding solution. Now, in addition to that, at Aviante, we also believe in the mobile first technology, right? So that's where it allows the candidate to complete documentation from anywhere with, while maintaining security and compliance. That is dramatically reducing a lot of these delays, because now they can pull it up on their mobile app and right from the palm of their hand, they could complete that instead of, worrying about paper process or even Adobe forms that can become complex and cumbersome. So with that, what we've done is we've, engaged with Equifax that provides a wonderful, compliance solution. And so we are using that and we've integrated that. So a lot of our clients have already started to use that, and more are considering it. And then, the other thing I'll say is all of this focused approach, that we're talking about, it helps employees follow this simple, easy to navigate process, right? It's easy for the employee. They can quickly pull it up. While when you think about the agency, the recruiters, or maybe the administrators, whoever's doing these, in charge of the onboarding process, it saves them valuable time to address real issues rather than, processing all this routine paperwork and dealing with blocking and tackling and chasing after people for forms and what have you. So, in my mind, from a product standpoint, well-designed compliance technology that removes a lot of these types of barriers, rather than creating them. It allows staffing agencies to move with great speed and confidence. So, it's both. We're addressing both of these.
Got it. Got it. Interesting. So, obviously having a configurable digitized approach makes it better for staffing agencies. Leah, what about for agencies that haven't audited their I-9 processes, or they still have a paper process? You know, staffing agencies are trying to operate a business. They're not necessarily thinking about compliance. If somebody were to call you up and say, you know what, I haven't audited my I-9 in a few years, what should I do, and how should I remediate the compliance issues without creating bigger problems?
Sure. And we have a lot of clients that call with that exact question that, I haven't looked under this hood in a long time and I'm a little bit afraid and want to see, I don't know what I don't know. And so, kind of, it's almost like walking out on the ice, the partially frozen lake, like you don't know when you're going to fall through. And it can feel that way, but it really is just eating that elephant kind of one bite at a time. And we always recommend if you have some hybrid, especially if you still have anything in paper, that you work with legal counsel for at least an initial kind of a spot audit, a random audit, right? Picking a sample size and see if something systemic presents itself. Because if it's systemic over those, it's probably over everything. And the reason we recommend it be done with an attorney is to preserve that under attorney-client privilege, right? So that we can cloak it as being protected from disclosure if you were to ever be audited by the government down the road. Going in and go ahead, Chris.
Well, no. So really, what you're saying is, if you haven't done it in a while, call your attorney, do it under a client-attorney privilege. Go through that.
Yeah.
Go through that. Go through that process, and then presumably you can do some mitigation without having to admit, that you've got 5,000 records that.
Absolutely.
Yeah.
And it's a fresh set of outside eyes. They can also look at your current state, look at what your policies say if you haven't looked at your SOPs and your internal workflows in a long time. Maybe it's time to tweak some of that, tweak some training, that kind of thing. See how you can prevent those types of issues from continuing. Maybe you've moved to a digitized solution, which eliminates about 95% of those human errors that we see on the paper piece. That's one step in the right direction. But just maintaining, having a look at the current state and see if it matches with where you need to be in order to be compliant in this space.
Mm-hmm. Now, one other thing I'm curious about: a lot of staffing agencies have adopted E-Verify. I think it's required now, and is it 23 states, 25? About roughly half of all states in the U.S. require E-Verify. But does that solve all or most immigration compliance issues? What protection does E-Verify actually provide, and where are there still gaps for a staffing agency that uses it?
It's such a big misconception, right? That if I get that green work authorized status, I am free and clear for all of time. And, it's really not always the case. And so what E-Verify does for participants is it tells those employers, if you run your folks through E-Verify and you've accepted reasonably legitimate documents in support of that I-9, and we tell you it's okay and this person is authorized to work, then we won't charge you down the road with knowingly hiring an unauthorized worker if it turns out that that person is not authorized to work, right? So it's eliminating the most egregious kind of penalty category for employers who participate. And the reason there is because it can't catch And it's getting better. It's getting, as states, BMVs and state agencies start to feed into the federal system, that's becoming a little bit more robust. But if somebody has my name, social security number, and my date of birth, and puts together a really good fake social security card and state issued ID, it's going to pass E-Verify because it matches the data that E-Verify has for me, which is just cross-checking Social Security Administration for the social security, date of birth, name. Does it match? Yes, clear, right? So it's not the complete get out of jail free card, but it does move you more towards reducing the risk of the higher level penalties.
Yeah.
And
So
lots of
we're-
clients are demanding, right? So not only are we seeing it states and half the states, but a lot of clients, end using customers, are requiring their staffing providers to utilize E-Verify prior to placement.
So we're getting close to the end of our time, and I want to say to the audience, if you have questions, I'm not sure we're going to get to them, but if you leave questions with us, we will certainly try to answer them. One more question for you, Leah, and then we should probably wrap up, which is, we've talked a lot about staffing agencies, but if you were an employer, and especially an employer who works with a lot of different staffing agencies, what steps as an employer would you take, and what would you expect from your vendor of choice in staffing?
Yeah, I think, we see a lot of that in client supplied agreements where folks land on that. And I think the biggest piece that we see end using customers driving to their suppliers is the expectation that you will be willing to contractually commit that you are running and screening your folks and processing Form I-9s in a manner that's fully compliant with applicable law. They're probably going to ask you to indemnify for any failure on your part to do so. You can't, and I caution staffing firms to be very careful. You cannot warrant that every person is authorized to work. You can't guarantee that. What you can say is we will comply with applicable law to verify work authorization and identification of every person before we send them. And that's a reasonable expectation. That's a service a staffing firm absolutely should be performing, right? So seeing that in client contracts is where a lot of clients will start. And then currently, end using customers are, following up with a dialogue. They're seeing the same headlines. They're feeling some of the same pressures that staffing firms are feeling. And so if I own a company that uses a staffing firm, I'm reaching out to my suppliers and asking them to verify for me that they're complying with I-9 regulations, because I don't want my staffing firm to be the impetus to a raid or and particularly if you have a large population of people out there, your clients and using clients are nervous about the risk you may be presenting and introducing inadvertently. So they're asking for those reassurances with more frequency today than ever before.
Very good. Well, I think we're approaching the top of the hour. We have a few questions that we're not going to be able to get to them, but I think some of them, and particularly for those that are coming from Aviante customers, we will try and address those on an individual basis going forward. I want to thank the audience. I want to thank both Leah and Sushma for a really interesting and very informative, fireside chat. And so thank you for joining us. And on behalf of Aviante, we want to thank our audience. We will be making a recording of this available to Aviante customers afterwards. So people should be able to go in and get this. So on behalf of all Aviante and on behalf of Staffing GC and Leah, thank you for attending, and we will end our webinar now. So thank you.
Thank you.
Thank you, everyone.